Welcome to Conozca sus derechos, Know Your Rights. This program is brought to you by the Hispanic Bar Association of Central Florida. It is our mission to inform our community of important legal topics affecting us all, and today we will be talking about criminal legal issues. I am Henry Lim, the Community Relations Chair of the Hispanic Bar Association of Central Florida. Today we will discuss various topics relating to criminal law. We will be discussing common mistakes and misconceptions surrounding these issues and provide information on where to go for help. During our program, we will hear from various attorneys in our community who are quite knowledgeable in the area of criminal law. Let's begin by introducing attorney Maribeth Gonzalez. Maribeth, how are you today?
I'm great.
Good, good. Tell us a little bit about yourself.
Well, I have a law firm in downtown Orlando, and I service the counties of Orange, Osceola, and Seminole. I practice primarily family law and criminal law. Before I became an attorney, I was a probation officer for Seminole County. I was tasked to do the high-risk pilot program for the GPS units, so that was pretty exciting. That was about 8 years ago. Now those units are everywhere. But that's about it.
Great. Well, thank you. And thank you for participating in our program today. Also with us today, we have attorney Jose Garcia. Jose, how are you today?
I'm great, Henry. How about yourself?
Good. Tell us a little bit about yourself, Jose.
Well, my practice is exclusively in criminal defense. I practice here in Central Florida and all the surrounding counties, Orange, Osceola, Seminole. And I have been practicing for over 8 years. Previously to going out on my own, I have experience with the Public Defender's Office. And like I said, I exclusively practice criminal defense.
Well, let's get right to it. I've been arrested. What should I do?
You should try to get an attorney and be advised of your rights. You might say things that are not favorable to you, and there might be possible defenses for allegations. And just because you're arrested doesn't mean you're criminal. You're going to be convicted of a criminal act or even that you're guilty. So you should always speak to an attorney to know any possible defenses.
Jose, on TV, we always hear attorneys say, don't talk to anyone unless you talk to me first. Why do attorneys say that to their clients?
It's very important to have an attorney present during any interrogations by law enforcement. As Maribeth stated previously, it's very important to know that what you say can and more likely than not be used against you. And even though you don't think you said anything incriminating, chances are the law enforcement will use it against you in a fashion that could ultimately give you a bad outcome at the end.
Well, what's the difference of having an attorney present during an interrogation? I mean, what does the attorney actually do?
Well, he knows the rights that you have afforded to you and could prevent you. You're not obligated to answer any questions. You have the right to remain silent. And having an attorney there could remind you of those rights and protect you from incriminating yourself.
Well, let's say that I don't have an attorney, and I've never had an attorney. My family has never needed an attorney, and the police starts questioning me. And now I can't even afford an attorney, so should I just start answering questions?
Absolutely not.
No, you should not start. Answering questions, and you have the right to an attorney. You would be assigned the public defender if you don't have an attorney. And the biggest misconception or clients' misconception that people have is they say, "Well, they didn't read me my Miranda rights." Well, they read your Miranda rights after they've done investigations. That's why it's so important to talk to an attorney, because everything you said before your Miranda rights can be used against you. And after they've read your Miranda rights, they have just warned you that it could be incriminating evidence.
Okay, and how does the whole public defender issue work, though? Who pays for that?
Well, it's usually the state of Florida is paid, but the clerk of the court and the court itself determine whether or not the indigent status has been accomplished. In other words, you can't afford a private attorney, so one will be appointed for you. Everybody's entitled to have an attorney represent them and when they're accused of a crime. So at any point, you would have to sign an affidavit showing that you are indeed indigent and can't afford an attorney, and at which point the clerk and or the court will appoint a public defender for you.
Okay. Let's move on to another example. Let's say that I get pulled over for a DUI, and the police ask me to breathe into the breathalyzer and subject myself to a breathalyzer test. Should I comply? What are my rights as a driver? Should I comply with the breathalyzer test?
Well, When you get stopped for a DUI, the breathalyzer actually comes into play after you've been placed under arrest. And when you signed up for your license, you gave consent that you would take the breathalyzer test. So if you do not, it would be a refusal, and there's consequences, and your license would be suspended.
What sort of consequences do we see? Are there any other?
If you refuse after the more than once, if you actually, it could be a misdemeanor charge for refusal on a second breathalyzer request. As Mayor Red stated, if everybody looks in their driver's license, the very fine print at the bottom, it says that you are consenting by exercising and having a privilege to drive in the state of Florida. You're consenting to all alcoholic exams. But you do have the right. You do have to take a breathalyzer exam given by the state of Florida, and there are consequences for not taking that exam.
Let's say that I know I've had a few beers, and I have a feeling that I may fail this breathalyzer test. Do I stand a better chance of winning a DUI case or a worse chance of winning a DUI case from that perspective? Put aside the fact that I signed this consent, but if I refuse to do it, do I have a better chance of winning a DUI case down the line?
Well, your normal faculties have to be impaired. So there's a misconception that you can't drink and drive. So for example, one glass of wine would affect me differently than one glass of wine would affect you. So first there has to be a driving pattern. There has to be a valid stop before we even get there for the breathalyzer comes in. And there's also in litigation stage, the breathalyzer could be questioned, was it properly calibrated? So there's more issues to this than just a DUI. You can drink and drive is whether your normal faculties were impaired while you were driving. Was there a driving pattern? Did you run over the stop sign? Were you swerving? So there's more to it. That's why you need to speak to an attorney so they can look at the facts of the case and see if you have a good defense or not.
So can the courts decide that you were driving under the influence without the benefits of a breathalyzer test?
I believe so, and it wouldn't be, well, the courts and/or a jury of your peers. But yes, they could not only use the driving pattern, what you exhibited in front of the police officers, any other field sobriety exercises that occurred on the side of the road, but also the introduction of as evidence of your refusal of not taking the breathalyzer could also be used against you.
What are the criminal consequences of a DUI? What are the penalties?
They could be very costly, obviously. The first-time offense usually runs with a 1-year driver's license suspension, 10-year impound of your vehicle, up to $1,000 fine, and some DUI counterattack school classes, victim awareness panel classes, community service hours, any drug evaluation and treatment as well. So it could be very costly.
What about subsequent DUI arrests? How are they treated by the courts in Florida?
It is an enhanceable offense. DUI, such as many other offenses in the state of Florida, are enhanceable, and which basically means that the penalties are increased for any second or third offenses. If a third-time DUI could potentially be a felony charge.
Well, let's say that I have a DUI. I've had DUIs and my license was suspended, but I need to drive for work. Are there ever any exceptions made during the suspension of a license?
Well, you can get a hardship license, but you would have to take the counterattack school, and you would have to apply at Department of Motor Vehicle. So it's a process. Remember, your license is a privilege, it's not a right, so you would have to adhere to the request.
What exactly is the process in obtaining a hardship license?
There is a period, what they call a hard time, that you can't have a license of any kind. That period varies with the amount of driving offenses you have on your record. And then later you would apply with the DMV, and they would analyze the situation and either issue a hardship license or a business purpose only license with certain restrictions, or they could deny you altogether.
When someone is pulled over, is there a requirement to show the officer the driver's license?
I believe there is, yes.
What about passengers in the car? Are they required to submit identification to the police officers?
Well, we're assuming it's a valid stop. So if it's a valid stop, then they have a right to ask for your identification.
What about the search of the vehicle? What are the police officers allowed and not allowed to do?
At the very least, they would need consent. In other words, they would have to ask to search your vehicle, and you would have to provide them with the consent to search your vehicle. But their probable cause could also exist for them to search your vehicle. In other words, an example would be if they decided that they smelled the odor of cannabis or marijuana in the vehicle, that could be sufficient for them to search your vehicle.
However, they can't search your vehicle, and this is where people have a misconception. For example, they stopped you because you ran a stop sign. They can ask you for you to get out of the car if there's officer safety involved, but they can't really search your vehicle unless you consent to it.
Right, great. It sounds like a very fascinating topic. We will take a break. Stay tuned as we discuss many other topics in criminal legal matters. Welcome back to Conozca sus derechos, Know Your Rights. Programming brought to you by the Hispanic Bar Association of Central Florida. I am Henry Lim, Community Relations Chair of the Hispanic Bar Association of Central Florida. With us today to discuss criminal legal matters are attorneys Maribeth Gonzalez and Jose Garcia. We've been discussing DUIs. One of the things that comes up is open container. What is the open container law in the state of Florida?
Well, the open container law basically, it's actually a civil infraction that it's non-criminal, but however, it could be added on as an enhancement to your DUI, showing the likelihood that you were impaired. It could be another form of evidence that could be used against you. And not only is the driver could be found culpable of an open container, but any passenger in the vehicle could also be found guilty of a open container violation.
So what happens if it's one of the passengers who happened to sneak a bottle of something in the back of a car? Would the driver face any consequences as a result?
No. Only the person who is in possession of that open container. Now, if the open bottle is on the floorboard somewhere and it's not really in actual possession of any one of them, any one person, technically they could all be charged with it. Now, whether or not who could be found guilty of it, that's a different question. But it could be called what's called constructive possession, which we may get into a little further later on.
And with regards to that, with regards to the open container, what people usually don't understand that an open container is a container for alcoholic beverage. It could be empty and it'll still be an open container.
Oh, wow. Well, we see on TV a lot where someone was charged with a crime. They're found not guilty in court under the criminal matter, but then we see them again in court over the same matter. Isn't there anything about double jeopardy? How does that work? Why are they allowed to bring in a similar matter again in court?
For example, let's use a battery. When you're talking about criminal matter, the state has a very high burden. It has to prove beyond and to the exclusion of every reasonable doubt. So it's a higher burden. When it comes to civil matter, it's a substantial evidence or preponderance of evidence, which is more likely than not. So with regards to the civil matter, you might lose on the criminal aspect of battery. However, there might be damages. You might have hospital bill, medical bills, and you might win in the civil case because you need, instead of restitution, you need payment for those medical bills. So that's one example of how you can distinguish it.
Okay, and how does Florida define battery? You brought up battery. I'd like to get a clarification about that. How does the state of Florida define battery?
Well, battery is basically an intentional touching or striking of another without their consent. So if I hit or strike Marivette without her asking me to, or giving her consent to do so, I could be charged and/or convicted of a battery.
Okay.
It could be throwing something too, like if It's not funny, but if he threw something at me, it could still be considered battery, and that's what people don't understand, the consensual. If I did not consent to you touching me, a simple grabbing like this could be considered a battery.
What is the difference between assault and battery then?
An assault is verbal threat of doing some kind of physical harm to somebody. And not only that, they also have the ability to do so. If I'm in New York and you're in Orlando, and I call you and I tell you I'm going to punch you in the face, I don't have the physical ability to do so at that point. So I can't necessarily be charged with an assault. However, if we're standing this close away and I say I'm going to punch you in the face, that could be an assault.
Okay, please don't do so.
I will.
What makes something aggravated? Because we hear aggravated battery, aggravated assault. What does the term aggravated mean in the criminal law setting?
Again, it could be an enhancement of some kind of crime. Usually in a battery, we're sticking with battery, if the person, the victim, suffered serious injuries, a broken nose or some kind of laceration, it goes beyond just touching somebody or grabbing somebody by the arm. That could be turned into an aggravated, and now you're no longer facing a misdemeanor charge, you could be facing a felony charge. So that, there's also other aggravating circumstances, but it usually just escalates the element of the crimes.
Weapons or a pregnant person, there's a lot of factors that can aggravate it.
I've heard sometimes that vehicles could be considered weapons. Is that correct?
Yes.
And how are vehicles considered weapons?
If I run you over, that's a weapon.
So would that be an example of an aggravated type of battery?
Absolutely. I've defended cases where attempted murder, where somebody sideswiped somebody else with a vehicle. We're talking a 3,500-pound car versus a 150, 200-pound human being. It could be considered a weapon. Okay. So absolutely.
Well, you brought up murder. You also hear in the news that someone gets charged with murder or manslaughter. Is there a difference between murder and manslaughter?
Yes. The elements that the state would have to prove are different. Murder is basically the killing of another human being with malice aforethought. In other words, you have to have a preconceived notion that you want to cause physical harm to somebody, and it ultimately ends in death. Manslaughter, there are two different kinds of manslaughter, but manslaughter doesn't necessarily have that malice aforethought. There's voluntary and involuntary manslaughter. The voluntary manslaughter is what maybe you've heard before, the heat of passion crime. You find your wife in bed with another, and you just can't control yourself, and you lose it for that moment, and it causes the death of another. That would be what's called voluntary manslaughter. Involuntary manslaughter would be recklessness to the point where it causes harm to somebody and or death to somebody, and jumping off or pushing somebody off a bridge or doing something that you didn't think you were going to kill them, but it ultimately was so reckless that it did end up in the death of someone.
And when you're talking about DUIs and correlating it to what we're discussing right now between murder and manslaughter, let's say that someone dies as a result of a DUI. What has been your experience? What do you normally see as the charge from the state of Florida against the individual, against the driver?
There is a DUI, vehicular manslaughter statute in the state of Florida. It specifically has certain elements that are intertwined manslaughter and DUI charges together with certain consequences, of course.
Well, let's talk about those consequences. What are the different consequences between a murder compared to a manslaughter?
Well, obviously murder, we have the death penalty here in the state of Florida, so we could face the ultimate sanction, which I think I'm totally against. I don't think I know I'm totally against the death penalty. However, or you could face life, up to life in prison. It's obviously a first-degree offense, a felony. As opposed to manslaughter, it could either be a second-degree felony punishable by up to 15 years or a first-degree felony punishable up to 30 years.
Okay. And what are the different classifications of murder? Because I've heard people say capital murder, first degree, second degree. How is that defined in the state of Florida?
That would be up to the elements of the crime, of what the state can prove beyond a reasonable doubt. Again, first degree capital murder is basically with malice aforethought. they knew they wanted to commit the crime of murder, and they had a preconceived notion of doing so, and they did. Second-degree murder, could be manslaughter, but the elements are different, and the state would have to prove those elements, and you could still be found guilty of a lesser included crime. So even though you're charged with first-degree murder, you still could be found guilty of manslaughter or second-degree murder.
Even if the state does not charge you with those specific crimes?
That's correct.
Wow. And what does the defendant in a criminal matter have to prove in a criminal law setting?
The defendant doesn't have to prove anything, and that's the biggest misconception. The defendant, the state has to prove beyond and to exclusion of every reasonable doubt the elements of the crime. And the biggest misconception is when you get a jury, you run a risk. The jury sometimes, most of the time, want to hear from the defendant, but as a matter of fact, the defendant doesn't have to say anything. But it's a decision that has to be made whether the defendant will testify or not.
And is that why we see many times on high-profile cases that the defendant does not testify?
Every case is different. It is ultimately the defendant's decision, not the attorneys, not the courts, not the state attorneys. It's up to the defendant to decide whether or not they wish to exercise their right to remain silent or they wish to testify on their own behalf. It can't be forced upon them, and the jury will be instructed that if they decide to remain silent, as Marivette said, a lot of jurors want to hear from the defendant, but if they decide to remain silent, the jury's instructed that they cannot use that silence against them. They have that right, and just like you and I and everybody else.
And that's why it's so important when you pick a jury, because you need to know about these possible biases, because they might want to hear, but the burden rests on the state.
Well, that was my next question was, as a criminal defense attorney, how do you handle that situation when selecting a jury, when you have a pretty good feeling that the defendant is not going to testify, that your client is not going to testify? How do you handle that at jury selection?
We have to make sure that we pick a jury that is fair and impartial and would be okay with not having to listen to our client testify on his own behalf. In other words, they don't have a problem with my client exercising his right to remain silent.
Great. Well, thank you very much, guys. Unfortunately, our time is up. We thank you for tuning in. I want to thank Marivette Gonzalez and Jose Garcia for their participation in Conozcas Sus Derechos. The Hispanic Bar Association of Central Florida is dedicated to community service, and in our upcoming episodes, we will continue to discuss criminal legal matters and other issues important to the community at large. We wish to thank Orange TV for their assistance in bringing you this program. For further information, please visit hbacf.com. Thank you for watching, and we'll see you next time on Know Your Rights.